When a case is brought to court, meaning when the agency files a neglect or abuse petition in the family court, that neglect petition contains the allegations and as with any time one party files a suit upon another party, the case will either go to trial or it will be settled, or at some point it can be withdrawn. It can also be dismissed by the court during or at the end of the trial. So we have a case here in which a neglect petition was filed against the mother. The allegations were educational neglect and don't remember the second allegation, but it had something to do with providing a certain kind of medical care for one of the children. And the case was settled about a year after it started. It was settled with what's called an ACD, Adjournment in Contemplation of Dismissal. There were terms and conditions that I agreed, I consented to. And the judge at the ACD hearing said that if at some point the city, the agency, would say that I had violated the ACD, I had violated the terms and conditions, then the case would be restored to the calendar and we would revert to, we would go back to the time before we had the ACD. And essentially what that means is we would go to trial on the neglect allegations. It's not clear to me, I don't know for sure whether at a neglect hearing the court considers what happened a year ago. Was the act a neglectful act? Was the child neglected as a result of my behavior? Does the situation fit with the statutory meaning of neglect? Or does the court consider the current state? How is the child now? How's everything? How's the situation at this time? So I don't know which of the two, whether it's only one or the other or both. that is considered. In my case, the allegation of educational neglect was remedied, and the other allegation was remedied as well. Both allegations were remedied. So by the time we came to the ACD hearing, there really were no I'd say there were no current neglect. There's nothing they could point to at this time that they could say, well, this child is being neglected now. And I think that in those instances where the underlying problem has been remedied, I think those are the instances when the agency is agreeable to an ACD settlement. Basically, what the ACD is, it's me voluntarily, me saying, okay, I'm agreeing for you to come into my home to speak with my kids. I'm consenting to it. And if I don't consent, what happens is that the agency has to prove in a trial that the government has compelling reason to override my constitutional right to be free from government interference, right? We all have this um, constitutional right to parent our children as we see fit. However, if a child is being harmed by the way we are conducting ourselves or raising them, then the government has uh, they have a compelling reason to interfere with the parent-child bond, and they have to prove. They can't just come in and say, well, the child is not in school, and that's neglect. This child's going to be harmed if she continues to remain in the care of this parent. No, they have to actually prove that the child has been impaired educationally. So I think at that point, when the agency sees that they have a weak case because the problem has been remedied, then they're like, let's just offer them a settlement, an ACD. They're going to consent to us supervising them. And it's a benefit to them because if they went to trial, the court might decide, well, there's no neglect at this time, case over. And then the agency cannot have continued contact with my family. So it's in their best interest to offer an ACD when they have a weak case. That's what I think. If you know otherwise, please let me know in the comments below. So my understanding was exactly what the judge said. These are the terms and conditions. Make sure your kid goes to school. Make sure your kids get their dental, medical, whatever needs met, vision, hearing, medical, dental. Make sure that you provide a home for them and, the basics. And I understood what the judge said when he said, if you violate this order, this ACD, then the case will be restored to the calendar and you will come to trial on the neglect allegations. Fine. That don't sound so bad, does it? So if the agency finds at some point that I violated the ACD, they can petition the court. They can write up a motion to the court and say, hey, this mom violated the ACD, this order, and we come back for a trial for neglect on the neglect charges. Well, everything that unfolded very differently than how the judge said it would unfold. Because an ACD is an order by consent of both parties, and the reason it's by consent is because the court cannot force a parent to open the door for government agents. The court cannot compel that. They can only compel it if there has been a trial on the neglect allegations and the parent has been found to be neglectful. I guess one of the things the court can order is all supervision, I guess. I don't know. If you know, please let me know. At any rate, in my case, when the caseworker decided in his mind, regardless of the facts, he decided in his mind that I had violated the order in that he would come to the home, ring the doorbell, no answer. No, he'd come at random times, random days, no answer. Why they would come during the daytime when my children are in school, I don't know. I don't understand that. You want to see the kids come when they're home. So, yes, if you're going to come every day during school time, I won't be home, my kids won't be home. And this caseworker wrote up a warrant affidavit. On his affidavit, he wrote, hey, I came to the home, rang the doorbell, called the home, nobody answered. I waited 15 minutes, no answer. Well, one time he came to the home when it was about an hour before my daughter was to return back from school. And he said he came to speak with her, to check up on her. And I said, oh, she's in school. So he wrote on that affidavit that he came and that I refused. I refused to let him speak with my daughter. He didn't write on that affidavit that I came at a time when the child was in school and the mother reported to me her child was in school. No, he didn't write that. He said I came to the home and the mother refused to let me speak with a child. Forgot to mention that the first time he sought an arrest warrant, he was actually seeing one of my children at their school. He was going every second week. And he got an arrest warrant for that child and the other child. I'm like, hey, dude, I mean, if you just saw this kid in school, what, you know, I'm like, what the hell? Why are you impinging on this child's Fourth Amendment rights to be free from unreasonable seizures? That was an unreasonable seizure. You just saw her at school and you said everything was okay there. She was doing really well. She was excelling in school. And And now you go and have that child arrested, detained, whatever language you want to use, have her detained, brought to the court by force, have her miss a day of school. Oh, interesting. It's a case of educational neglect, yet they are the ones blocking the kids from going to school. So, at any rate, second arrest, that child had aged out and he wanted access to the younger child. Derivative neglect, right? Derivative neglect allegations on any of the other children. So he writes on his warrant affidavit, I came to the home and the mother refused. She's refusing to comply, to cooperate with this ACD order. She's not listening. I'm not saying the precise words, but something like this. And the mother is a threat to her child, and the court must do everything possible to ensure the safety of this 14, almost 15-year-old child, about whom there were never any complaints by a doctor, by a teacher, by a neighbor, by anybody. The power got to his head, I think. So here's the point. If the judge had told me, hey, ma'am, if you violate that ACD order, the agency can come in and say that you violated, and they can have the cops come to your home, and, I can enforce that order. The judge didn't say that. And I think the reason he didn't say it is because an ACD order cannot be enforced. It's a voluntary agreement. I don't know. If you know, let me know, please. I don't know how this all works. All I know is the judge told me what would happen if this agency believed at some point that I had violated. I don't believe I violated it, but they believed I did. So that's another thing that I'm trying to get information on. What exactly is a violation of an order? I would think if I continued to do those very things that resulted in the initial allegations, that might be a violation. I don't know. At any rate, if I if the punishment for violating an ACD is cops breaking down your door at 6 in the morning, then nobody would accept an ACD. Who wants that? We would choose going to trial. I'll go to trial. I'm not taking my chances. You might decide one nice day that I violated this ACD. You're going to send the cops to my home. Not doing that. So yeah, that's the point of this episode, that an ACD is an order by consent. Please comment if you know otherwise. And an order by consent cannot be enforced by sending the cops to your home. No. Because when cops come to the home, they've got to abide by the reasonableness standard, and there's another standard. I'm not remembering it at this moment. There may be more than one standard. But for the government to come into the home with that kind of force, literally break the locks and take the door off its hinges or hinge, and barge in with ammunition. I mean, what do you call that? With guns, tasers, batons, all the stuff they've got. Is that a reasonable search and seizure? I ask you, is that a reasonable search and seizure? Really? Where's the reasonability of this? Where's the reasonableness of this? Because I violated an order? I violated by not being home? I didn't abuse or neglect. And they certainly didn't make allegations that I was abusing or neglecting. They just wrote that they came to the home and I refused to cooperate. I refused to comply. But the refusal to comply or cooperate wasn't causing harm to my child. That's the thing, you know what I'm saying? If my refusal or my not cooperating is not causing harm to my child, then the government has no business violating my Fourth and 14th Amendment protections. And when they do that, that's a big problem. So I'll end this episode for now. Thanks for listening. I hope it's helpful to you in some way. I welcome your comments in the comment section below. Take care, everybody. Bye.